Order. Andrew Rosindell to move the motion.
Good morning, Dr. Alan Khan, and as always, it's a pleasure to serve under your chairmanship. And I welcome the opportunity today to bring the issue of the impact on British society of the Equality Act of 2010 to the floor of the House. A topic which I believe is increasingly being raised by my constituents in Romford, but also more widely across the United Kingdom, people whose lives are affected on a daily basis because of this legislation. It has also been subject of detailed research in the recent report by the think tank Don't Divide Us, co-authored by Dr. Alka Siegel-Cuthbert and Dr. Anna Lautfi, which I commend to members of all parties and the wider public. Dr. Alan Khan, for centuries, our common law tradition has been the vanguard in the defence of what we consider our liberties as Britons. Ushered in 900 years ago, emboldened by the Magna Carta of 2015, common law enshrined the once revolutionary principle that all individuals are equal before the law, judged not as members of groups, but as subjects of the Crown with inherent rights. From this tradition came trial by jury, and itself has its origins in Anglo-Saxon England, habeas corpus, and the presumption of innocence. Were these gifts from Brussels or Strasbourg? Of course not. They are the hard-won fruits of our own history and the innovative quality of our forebears and the generations that have come before us. When the Equality Act was passed in 2010, we were told by the now noble Lady Baroness Harman that it would end discrimination, give everyone a fair chance in life, and bring transparency. Fine words indeed, yet they give the impression that Parliament can, through sheer willpower, eliminate some of the more damaging and derisive aspects of human nature. 15 years on, the reality is, I'm sad to say, very different. The Act has not united our country, it has divided it. It has not reduced discrimination, it has fuelled grievance. It has not strengthened our traditions of fairness, it has undermined them. In fact, it has fanned the very flames it sought to extinguish. In the first instance, it is so woefully drafted. To take an example, consider the alleged definition of race. Section 9 defines this as including, but not limited to, colour, nationality, and ethnic or national origins. This is imprecise, confusing, and has generated a grey area in law. Simply put, it is a poor expression of parliamentary intention, whatever that was at the time. We are also seeing absurd contradictions. Under Section 13, subsection 5 of the Act bans racial segregation, and yet guidance under the Equality Act allows organisations to create separate spaces based on combinations of protected characteristics. In practice, that could actually mean the state sanctioning racial segregation in Britain in 2025, all in the name of equality. The Act and the imported ideology that underpins it has created a culture of division and victimhood. It is the legislative foundation of what today is called DEI, diversity, equity and inclusion, and the ever-expanding industry of woke training sessions and quotas. I certainly will.
Is the honourable member aware that bad as that situation is, it is in fact accentuated and worsened by the prevailing situation in Northern Ireland, where not only have we the Equality Act, not only where we have equality legislation, but pursuant to Article 2 of the Protocol governing the post-Brexit arrangements, there are applied additional rights, so-called, which have been used by activist judges to strike down already two pieces of legislation from this Parliament, the Rwanda Bill and the Legacy Bill. Now, whether one agrees with the content or not, isn't it quite appalling that within one part of the United Kingdom there are foreign jurisdictions imported through the protocol which gives different rights, so-called, than elsewhere in the United Kingdom?
Just before I call Andrew Rosindell again, I'd just like to remind members that if they would like to make a significant contribution today, please bob and I will get you in for the debate. Thank you. Andrew Rosindell.
I thank the honourable member for his intervention, and of course he's absolutely right that sadly in this country we have divided our own nation by treating Northern Ireland differently than the rest of the kingdom. That was a huge error by, I'm afraid to say, the last Conservative government in agreeing to the Northern Ireland Protocol and then the Windsor Framework. I am against both, and I look forward to a future government repealing them so that we have one united kingdom where all people in these islands are treated equally and the same. And so, Madam Chairman, as set out clearly by Don't Divide Us, the truth is that the Equality Act should really be called the Inequality Act. Instead of treating every citizen as an individual, equal before the law, it elevates certain so-called protected characteristics and encourages people to see themselves not as fellow Britons, but as members of competing groups. Far from promoting individual merit, the Equality Act is simply state-sponsored identity politics. And what has been the result of this? Our English legal system sadly has been Americanised through the introduction of a corrosive culture of litigation in the workplace. Since 2017, race discrimination claims in employment tribunals have tripled, with more than 200,000 cases, and yet only 5% of these have actually been upheld. Now, that tells us something very important. Either Britain is riddled with invisible discrimination that even our judges cannot detect, which, given the richness of our legal traditions, I simply do not accept, or the law is unfit for purpose. In practice, it has turned the workplace into a battleground of claims and counterclaims. Despite the small number of successful claims, these statistics still demonstrate the damage it has caused in places of work. Victim culture has not only been allowed to dominate the workplace, but has been actively encouraged by this legislation. To take one example, in the case of Williams v Nottingham, the judge noted that the claimant, and I quote, thinks that the mere existence of racial disparity is in itself proof of racism. However, the damage goes much deeper. The Equality Act is not simply a tidying up of previous anti-discrimination laws. As hinted earlier, it represents a wholesale shift away from our common law tradition where everyone is equal before the law towards a continental EU-style system based on substantive equality, group rights and bureaucratic enforcement. It was inspired by EU directives in direct contradiction of our legal heritage. It hands enormous power to quangos, activist lawyers and DEI consultants, while eroding the space for free thought, free speech and personal judgment. Some honourable and right honourable members suggest that repealing the Equality Act would mean enabling inequality. But that is simply wrong. Just as if we were to repeal the Human Rights Act, that it would abolish human rights. Repealing equality, the Equality Act, does not abolish equality. Human rights and equality existed long before these Blairite statutes. In fact, equality, within the definition that we would ascribe it today, really finds its roots here in these islands in the United Kingdom. The underlying ideology of diversity is not neutral, like many on the left of politics might suggest. It treats diversity as an unqualified good, and by implication, majority identity, whether English, Scots, Christian or British, as a problem to be managed. That is why so many of our constituents feel that these laws are not written for them, and certainly not in their interests. The majority, who simply want to live by the law, pay their taxes and contribute to society, feel increasingly alienated by a system that tells them that they have privilege that must be checked, while others are encouraged to claim special treatment. This does not sound like equality to me. The Equality Act has given rise to a sprawling industry made up of an army of bureaucrats, consultants, trainers and lawyers, all feeding off the taxpayer. Repealing it, as I am advocating today, would mean considerable savings, as vast sums of public money is poured into funding this circus. Repealing the legislation would both restore common sense to our institutions and deliver real value for money to the taxpayer. Estimates suggest substantial savings, with annual reductions in compliance costs running into tens of millions, probably thousands of millions. It's very hard to quantify, but it's a huge sum of money if you consider all the public institutions and the money they spend on promoting the DEI agenda. Money that should be going to our frontline public services instead. The NHS Confederation itself has indicated that DEI roles alone are costing the taxpayer nearly 40 million. I'm sure that's a way underestimate of what's really being spent. And that is just one sector. Goodness only knows what the total bill is across the public sector. In local government, the police, educational institutions, and not, of course, to forget the BBC. It's time to put the taxpayer first and end this costly charade. The private sector and the corporate world would have also been sucked in to this dangerous ideology, spending vast sums of money in ticking every woke box whilst engaging in constant virtual signalling. None of this is cost-free to the public either, as ultimately it all must be paid for out of the pockets of their customers. Some will say, but you had 14 years in government. Why didn't you repeal it? To which I say, I, Member of Parliament for Romford, I have opposed this Act from the very beginning. I never believed it would deliver what was promised, and I have consistently warned of the dangers of this ideological agenda. Sadly, too many in my own party doubled down on it. Some even wanted to extend it. I know that the Shadow Minister today is not of that view, but sadly over the last 14 years, many in my own party sucked it all up and carried on with it and extended it. Well, that was a grave mistake. It really was. And Britain is suffering as a result. Now, the Labour government talk of introducing new Race Equality Act, another bright idea from the same failed mindset. The Equality Act has caused so much harm. Adding another layer of identity politics into the law will make matters even worse. And I urge the government to rethink that idea. Increasingly, we likewise hear calls to adopt a legal definition of Islamophobia. And what kind of society do we want to live in, where these proposed definitions will conflate criticism of an ideology or a religion with hatred of people? To criticise Islam as a religion is, Madam Chairman, not the same as hating people of the Muslim faith. Indeed, freedom of thought and freedom of speech require the ability to critique religious ideas, no matter what the religion may be. To criminalise such critique would be wholly inconsistent with the liberal democratic principles that have evolved in this country over centuries. It is more important than ever that we, as members of Parliament, in this, the mother of all parliaments, do not cower from taking decisions that at face value may seem unpopular because, trust me, the residents of my constituency in Romford, and I believe in every corner of this United Kingdom, would wholeheartedly endorse the reversal of these laws, as the problems we face lie at the heart of the legislation itself. So, in my opinion, we should repeal the Equality Act, root and branch. We should repeal the Human Rights Act, and the United Kingdom should withdraw from the ECHR. Indeed, we should dismantle the Blairite constitutional reforms that have corroded our democracy and wedged our politics between, on one hand, a long-standing tradition of parliamentary sovereignty, where power rests in this place, the King in Parliament or the Crown in Parliament, and on the other hand, an attempt at an American-style separation of powers, which has led to the outsourcing of Parliament's ability to govern by so-called experts. Both of these systems are mutually exclusive. We must pick one. And as a Conservative and Unionist, I see the intrinsic value of defending the constitutional traditions that have embedded itself in these islands for 1,000 years and which have been exported successfully around the world to the Commonwealth nations in particular. We must return to the great principle that has served this country well for centuries: equality before the law for all citizens, regardless of race, religion, gender, or background. That is the British way. That is our common law tradition. That is the true way to guarantee equality. The Equality Act is not bringing our people together, rather it is driving them apart. It is fueling an imported woke culture, an unmeritocratic DEI bureaucracy, and a corrosive culture of grievance. I believe we must therefore challenge the equality law house of cards constructed over previous decades and topple it to the ground, or face the prospect of an ever more divided society. We should instead be proud to identify ourselves as British, first and foremost, and truly glad to live in a society where all are treated equally under the ancient laws and customs that have made these cherished islands the great nation that it is and must continue to be.
Andrew Rosindell to wind up.
Thank you, Dr. Khan. May I thank you for chairing today's debate, which I think has been extremely valuable. We've had some excellent contributions, different opinions, but we've debated this in a respectful way. There are issues to be addressed, and all members today have made extremely valid points coming from different angles. And I'd like to particularly thank honourable members for Wolverhampton West for his remarks, and I took on board the point he made about caste discrimination, which is very rarely spoken about, and I thank him for drawing that to our attention. I'd like to thank my honourable friend for Strangford, who always makes incredibly valid points in all the debates that he speaks in, and he made the point that we may have differences, and we all do. We are all individuals. None of us are the same, but we have to live side by side. And legislation should be empowering the British people to live side by side in a free society, not pitting itself against each other and accentuating division by emphasising differences between us. We should be united as British people rather than actually looking at ways how we can be more divided and act like we're victims. And too many, I'm afraid, in our society today are doing that, because I think the Equalities Act has created that culture. And my honourable friend for Reigate made some extremely powerful comments, and I agree with everything she said, particularly about the public sector, local government especially, how the diversity culture has taken over, wasting so much money, causing so many divisions, and ignoring, my right honourable friend, member for East Surrey made the point about focusing on what really matters to real people in the real world, rather than looking inwards. Let's focus on providing good, efficient public services, rather than draining resources on this diversity agenda. I'd also like to thank members for East Londonderry and North Antrim. They're not here at the moment. They also made extremely valid points, particularly about the division of Northern Ireland, the rest of the United Kingdom, which I've always opposed. And finally, the right honourable member for my friend from East Surrey, who absolutely, I think, got to the point of where this has all gone wrong. All of us want to see people treated fairly and decently in a society where freedom is cherished, but it doesn't all have to be legislated for. Often things evolve, society changes in a natural way. If you try and legislate for everything, it's just a gift to the lawyers and the judges and the consultants and all the people that will monetarise legislation that gives them those opportunities. And finally, to the Minister, the member for Feltham and Heston, who I've always respected, and she spoke brilliantly today, made points that I didn't agree with, but many points I did agree with. I think we've all been subject to hateful language. I think as members of Parliament we get that probably more than most people, and hatred is wrong in any context. We should always treat people with respect and kindness and generosity, but at the same time prevent those with bad intentions to cause more divisions. And so the legislation needs to be minimal, rather than legislation actually opens up more opportunities for division within society. So ultimately, Dr. Alan Khan, I believe in freedom with responsibility. I don't believe that diversity is always the right answer. It can cause division, and I think that equality can sometimes be the opposite of freedom. So let's get back to basics. Let's be proud of our British heritage, which has always been based on fairness and equality under the law of these islands. And I thank all members for participating in this important debate. And those who have not had the chance, please get a copy of this report, because this does actually explain a lot of things which I think we as members of Parliament should be addressing today. Thank you.
The question is that this House has considered the impact of the Equality Act 2010 on British society. As many as are of that opinion say aye. Of the contrary, no. I think the ayes have it. Order, order.
Suspend.